Good morning. How's everyone doing today? All right, so today is Tuesday, September 10th. We have 5 cases on the docket today, but only 2 are scheduled to argue. We'll be taking a brief pause in between the 2 cases that are arguing because we'll be switching out the panel, okay? So the first case that we have is case number C240040, In Re SB, and this case has submitted on the briefs. And then we have case C240047, Phil Finn et al. No, we've switched this. Second, we have case C240166, June Ma versus Cincinnati Children's Hospital. This case is arguing. If you can identify yourselves and your readiness to proceed.
Mark Mesabov with the appellate.
Good morning.
Beth Bryan from Children's Hospital.
Thank you. And then we have case number C240047, Phil Finn versus Jennifer Sizer. This case is the one that we will be taking a pause before we hear our arguments on that. Counsel, I presume, is here. If you can please identify yourselves and your readiness to proceed.
Adam Sherr for the Finns.
Okay.
Michael Spillane for the Sizers. Ready to proceed.
Thank you. The fourth case we have is case C240039, State versus Joshua Griffin. This case has submitted on the briefs. And the last is case C230495, State versus Leonard Walker, also submitted on the briefs. I want to do a mic check. Does everybody hear me? Or is my mic low?
It's low.
It's low, okay. So let me see if I move it closer, if that's what the issue is, because this was brought to my attention yesterday. Is it still low?
I can hear you okay, but it's a little,
Okay,
perhaps more people, but there would be.
okay. I don't know if you can get Tyler real quick for us, and whenever he comes is when he, okay. Tyler, this is something that we had an issue with yesterday, and I forgot to bring to your attention. There's something with this mic that's low. And there were people that weren't able to hear yesterday.
If you bring it towards you and you speak towards it, I think it'll be fine. I think you were sitting away and weren't getting as close yesterday. So,
I mean, is this,
It's okay. I'm slightly.
Okay.
So I'm like,
all right.
Right.
All righty. Well, let's go ahead and move forward. And then Tyler, maybe after a panel, you can look at it, just to make sure there's not anything else to adjust. All right. Good morning.
Good morning, Your Honors.
Would you like to reserve time?
I would like to reserve 5 minutes for rebuttal.
Okay.
Thank you.
Whenever you're ready, you can start.
May it please the Court, Dr. Ma has raised 3 assignments of error. However, due to time constraints and for the purposes of this argument, I will address solely the errors contained in the instructions submitted to the jury and rely on our briefing for the remainder of the assignments. First, Your Honor, the instructions related to just cause were inherently confusing and/or misleading to Dr. Ma's substantial prejudice. The cause of the confusion and the misleading nature of the instructions is the language informing the jury that, quotes, "You may consider the following communications and documents as the basis of the contract: the 1999 offer letter, Dr. Ma's acceptance, the 1997 tenure document, the 2007 retention letter, and this is the language I wish to emphasize, any other evidence you conclude forms the basis for the contract between Dr. Ma and Children's."
well, so I understand your argument on this, but I guess, at least when I was writing the prior opinion, part of the issue was like, we don't have an integrated contract here. If there was an integrated contract, then that instruction would be clearly wrong, right? But because we don't have an integrated contract, we have this series of communications, and we were reacting to the case that was presented to us by both sides, So like, we don't know what else might be out there that might come up in discovery or anything like that. And obviously we were remanding for the consideration of extrinsic evidence to help, elucidate the contract. So I think in light of that, like, what is so problematic about that phrasing by the trial court?
Well, I think Your Honor pointed out the basis for the court's handling of the appeal, the language that the court provided in instructions for the trial court. But if we agree that there was not an integrated contract and that you had to rely on extrinsic evidence, what you were asking, as I understood from the trial court and from the jury, is to interpret the contract that was formed by the parties during a relevant time period. But this instruction goes well beyond the concept of extrinsic evidence to interpret a contract. It was asking them to find any other evidence they believed served as the basis for the contract. And at the same time the court is giving that instruction to the jury, the court is not instructing the jury as to what a formation of a contract is. How do you form a contract? What are the elements of a contract?
I mean, did you all ask for that instruction?
Well, we thought that the court was instructing the jury to find extrinsic evidence to interpret the contract. But the judge over...
But I think like the issue wasn't like, what are the elements of the contract? The issue was, what does just cause mean? And did Dr. Mock, satisfy his obligations under the contract?
Well,
And really, like, and this gets into your other issue on the instructions, but as I look at that, like, those are two sides of the same coin. Like, it's not, their argument was he didn't perform under the contract, that gave us just cause to terminate. It wasn't as if just cause was something independent, like he got convicted of a felony or something like that, which would make more sense for them to bear the burden. But when it's the flip side of he just didn't perform, like, why should that be an affirmative defense?
well, it should be an affirmative defense, Your Honor, because the court will remember that in its decision, the court found that the contract between the two parties involved tenure. That was the contract. And by tenure, contractually, and this is important, Dr. Ma was entitled to continued employment absent just cause. That meant, as part of the contract, he would remain in employment unless Children's proved that he had just cause to terminate his contract. It wasn't Dr. Ma's contractual obligation under tenure to prove there was no just cause. The burden was firmly, exclusively on Children's. If they're going to fire him for just cause, at least tell us what the just cause is in the contract.
But they did. I mean, they told you that the just cause was he wasn't generating revenue, he wasn't going out there hustling for grants. Like, they made that clear from day one. And in my mind, the question was, does that equal just cause or not?
Well, that was their burden to prove.
Mm-hmm.
The evidence that we rely on is the evidence that just cause in this concept, in this context of a tenured professor, is unprofessional behavior, not a failure to meet some expectations and an evaluation. That's a whole different ballgame. Evaluations are not contracts. They are measuring sticks. They are there to incentivize and to inform as to where you can improve and how we can help you
So,
improve.
counsel, in light of your position that the evaluations were not a part of the contract,
Correct.
what should the trial court have instructed the jury as to its consideration of extrinsic evidence?
It could have informed the jury that the role is to interpret the contract that was formed, and the contract that was formed was that Dr. Ma was entitled to continued employment absent just cause, which the burden for which is on Children's Hospital, not to require Dr. Ma to prove the absence of just cause. The failure to provide an affirmative defense instruction changed the entire complexion of the case. Placing the burden on one party versus the other determines who's going to present evidence, what evidence they're going to prove, and why they're presenting this evidence. Well, we are there then to prove that an evaluation is not contractual. It should have been on Children's part to prove that evaluations were contractual. They should have proved that Dr. Ma agreed at some point that there was a meeting, and that there was a meeting of the minds, that a failure to meet a supervisor's expectations in an annual evaluation is just cause for termination. There's no evidence to that effect, none whatsoever. The testimony,
How do we weigh the jury's interrogatory response in that regard? Because the jury seemed to identify that it was the failure to meet this expectation that amounted to just cause in its written interrogatory response.
well, that's the problem. The burden should have been placed on Children's, as I said, to prove what just cause is. And there should have been evidence. If they're going to say that failure to provide deliverables in a evaluation, 15 years after the contract was formed, constituted just cause. But remember as well that the instruction from this court to the trial court was to discuss documents arrived at during the relevant time period. Well, these evaluations were not made during the relevant time
Well, but
period.
I think that's one thing that I was curious about, because I didn't see, like, I almost would have expected a motion in limine to exclude that type of evidence from you all, but I didn't see, at least I don't see any assignments of error related to that in your brief. And so, like, if you aren't challenging that evidence coming in at this point, then it seems like it was all fair game for consideration by trial court.
Well, I think there's a difference between the admissibility of evidence and the weight of the evidence. The fact that he was evaluated, we think, was relevant because other individuals were also evaluated. Other individuals, and there was a whole chart full of them, failed to make their.
But you got that in, right?
We did get that in.
Okay.
So I don't think it was a question of the admissibility of the evidence. The jury was fine. Look, this couldn't be just cause because look at all these folks who had the same problems with Dr. Ma, and none of them got terminated. So from our perspective, it wasn't a question of admissibility of the evidence because we wanted the evidence of the comparators in. The question was, again, this goes to burden of proof. It goes to what this evidence of any other evidence, which gave them carte blanche authority to pull out any document.
Counsel, would you agree with me that there are conceptually, potentially, two different buckets of evidence in this case? Evidence going to the definition of just cause and the understanding of that term between the parties, and then evidence going to whether in the history of Dr. Ma's employment there was just cause for his termination. And do you agree with that, that those
Yeah,
are
that
two different
sounds-
things?
That sounds reasonable.
Okay. And that potentially there could be similar evidence that both define just cause and demonstrated that there was or was not just cause, or that the proof could be different for these two categories?
Well, I think the proof could be different. I mean, in our view, the jury fixated on these evaluations. And the problem we have with that is the instructions, again, gave them carte blanche authority to select any documents for whatever reason they wanted to without any limitation on the timing of those documents, the context of those documents, the purpose of those documents, the use of those documents, and any absence on the meeting of the minds that this was part of the contract.
Well, doesn't the instruction say that the jury has to find the evidence forms the basis of the contract? So wouldn't the jury need to determine that whatever evidence they're considering was a part of the agreement between Dr. Ma and Children's Hospital?
Well, that's true. But the problem with that is there were limitations to when the contract was formed. According to this court's opinion and its instructions of the trial court, they were to consider any documents that formed the basis of the agreement at the time it was entered into. That language the trial court refused to provide. We made a specific request. You need to put in that limiting language. The court refused to do so. And we pointed out that the language we were requesting to be included came from this court. So there was an understanding that by 1998, a contract had been formed. Well, in 1997, Dr. Ma got tenure, and that changed the entire contract from anything and everything to just cause. And therefore, it seems to be, it was incumbent upon Children's to prove and the judge to charge on that, what that just cause was. But that was never done, so that the jury then felt they could pull out of the air. They didn't pull it out of the air. Counsel for Children's argued they can consider any other documents, including the RPT documents. What did that have to do with this case at this point? Dr. Ma already had tenure.
Counsel,
Why should
thank
they
you for your arguments,
consider that
unless there's any
language?
other questions. Did you have anything further you wanted? Okay, thank you so much.
Thank you.
May it please the court. Like my friend, I'm going to focus on the jury instructions unless there are questions on the other two issues. Judge Bergeron, I'm going to start off. The jury instructions tracked exactly what this court remanded for the jury to decide whether the Children's had just cause to fire Dr. Ma. And my friend focuses on one snippet of those jury instructions, and what the law tells us is that we have to look at the jury instructions as a whole.
Well, then, in that vein, let me ask you, and I don't have all of the jury instructions in front of me right now, but if you're asking the jury to conclude what forms the basis of the contract, is the jury instructed on, like, what are the elements of contract formation? Like, how does it know how to make this determination?
Sure, Judge Bergeron, I was going to go to that point. You asked my friend that question, did he ask for a jury instruction on formation? He did not. And what I will say is that the court gave jury instructions on the key terms in the contract. Right out of the gate, it picked up the language from June Ma 1, that it was a series of communications over a number of years. In his reply brief, my friend argued that that language should have picked up the 4 documents that he thinks was key. But during the charge conference, he agreed to that language. It's at page 1261 of the transcript. So he didn't argue for that more expansive language that he wants now. The court instructed the jury that just cause was not part of any of the written contracts, but it was or any of the written documents, but it was part of the contract. The court instructed the jury that Dr. Ma had tenure, and that tenure meant that he had continuing employment absent just cause to be fired. So those were the key language. It also instructed the parties that we disagreed about the meaning of just cause, and we disagreed over the funding instructions. Again, tracking June Ma 1 and 2 exactly. And then it picked up the pattern jury instructions on extrinsic evidence. What do you have to look at to determine the intent of the parties? So the key elements of the contract were given to the jury.
So, and like, where does this italicized language that is focused upon in his brief, does that come from pattern instructions? Like, where did that come from?
It in part came from actually June Ma's proposed jury instructions. If you go back and look at the instructions, which is at page, or in the record at 166, his proposed instruction on how to figure out the answer to the question about what just cause meant was, in answering this question, you may consider the testimony of the witnesses, their credibility, and their ability to speak to this issue, the substance of any document that formed the basis of the employment contract between Dr. Ma and Children's, including Dr. Ma's status of the tenured professor. That language that he puts in, if you go in and look at his brief, forms the basis of the contract, is in there twice. But the original instruction came from Dr. Ma, and it's in the record at page 166, or in document 166. When we were having the charging conference, we were having a dispute about language that relates to what the actual contract was. I wanted an instruction that included language about the RPT guidelines. So when Dr. Ma was promoted, considered for tenure and promoted, there were documents outlining his obligations as a tenured professor. Dr. Boat testified about the obligations that were in place in 1997 when he was promoted, and again in 2002, those requirements were amended, so they were in place in 2007 before Dr. Ma was renegotiated his contract, Judge Tice, as you referred to it, that Ma won. We wanted to talk about those. Mr. Metzenbaum did not want that instruction, so Judge Nestor came up with this language as a compromise that we could argue to the jury that the RPT guidelines were part of the contract. That's where the language came from, but the original language came from Dr. Ma's instruction. Judge
Counsel, do you agree with me about the two categories of evidence?
Yes. And what I would say, you asked a question that had to do with what should the instruction have been related to just cause. And what I would say is that when we argued in Junma 2, Judge Bergeron, you asked this question of my colleague, what should the jury instruction look like? And we wanted to pick up language that was from case law about neglect of duty. When we went back down for a remand, the instruction that Junma proposed included kind of this default language that just cause normally means neglect of duty, dishonesty, or unfaithfulness in your service. So the jury was given default language and then an instruction that you could consider, the normal meaning of those words and then look to see if there was some other meaning attributed to the parties. So the backup default language is neglect of duty is just cause. The evaluation showed that he was not performing his duties to fund his research through external grants. And this was something that was put in the language in Junma 1. There is clear language from you at paragraph 5 that his duties include the obligation to fund his research through external grants. When we were here on Junma 2, it was focused in on a number and what the actual number was. What I will tell you is that the evidence put in from 1993, when Dr. Bode arrived, through the time Dr. Ma was fired, every single employee testified that the funding obligation was that Dr. Ma had to fund 70% of his salary through research grants.
So, counsel, one possible interpretation of the outcome in this case and the decision reached by the jury is that they accepted a traditional definition of just cause, needing no extrinsic evidence to define that term, and that they looked at the evidence presented in the case and determined based on the evaluations that there was a failure under the traditional definition of just cause.
Correct. And, Your Honor, when you're looking at whether you should reverse if you think that the jury instructions are wrong, you have to look at the face of the entire record, and it has to be apparent on its face that the jury committed some sort of error. And I don't think that's true when you look at the jury interrogatory. What they said was he wasn't meeting his expectations, so we fired him. And those evaluations showed that he wasn't meeting expectations. There's no evidence that the jury created a new contract or created new obligations, as my colleague argued.
And so, there's the debate between you two about whether this is an affirmative defense or not, and the case law seems surprisingly sketchy on that. Is this the type of case where we need to make a definitive conclusion, whether it always is or always isn't? What is your perspective on that?
So I think the answer to that question is no. And I'll tell you, when I went in and looked at the case law, there is not a single case where a court has affirmatively address the question of whether something is an affirmative defense or not. There is language talking about, I would say it's dicta if the employer has to show that they had just cause to terminate an employee. Judge Bergeron, in your opinions, you said if Dr. Ma wants to recover back pay, he has to prove that Children's breached the employment contract. And I understand when we're talking about the
I
language.
wasn't
how courts-
focused on the burden of proof at that point. but-
Correct, and I think that's the issue with all these opinions. The issues in front of those courts are not addressing the burden of proof. They are addressing something else. When we look at the case law, there are 4 cases that he discusses. 2 of them are summary judgment decisions, so those don't have anything to do with an affirmative defense. The other 2, the first one is from 1902, it's a Supreme Court case, that also doesn't address affirmative defenses, and it predates the Dyckman case on affirmative defenses. We also have the, just kind of the default rules. We're looking at Rule 8, is just cause an affirmative defense? The answer to that is no. There's no statute that requires just cause to be asserted as an affirmative defense. So then
No pleading obligation either.
No, there's no pleading obligation. And the Dyckman case says we look at the allegations in the complaint to determine whether there's an affirmative defense. Paragraph 29 of his complaint, he alleged that Children's breached the contract by firing Dr. Ma without just cause. We asserted a defense that we did not breach the contract. That doesn't turn it into an affirmative defense. So there is a scenario where you can imagine that the pleadings would require an affirmative defense in an employment contract. You know, employment discrimination, you fired me over race or gender, and the defense is, no, we fired you for just cause. But that's not the situation here, and I don't think that you need to, stray from 100 and almost 200 years worth of precedent about how you determine affirmative defenses in this case. And
Well, I
create a
also think it
special
may
rule.
be different depending on whether or not this is all itemized in the contract, because the contract could essentially place burden on one side or the other.
It could, but even if you step back and you look at the more traditional question of where this comes up, it comes up oftentimes in workers' compensation. Even then, the employee has a burden of proof to show that there was not just cause to fire them. There isn't some default rule that is at play that I think the court could fall back to. And I do think it's important because this kind of frames up the entire issue in the case. And even if this court were to kind of be moved by the affirmative defense argument, the Stern case is directly on point here. In that case, there was an error in the jury instructions on burden of proof on a defense of equitable estoppel, and the court still didn't reverse because they held that the party that should have bore the burden of proof actually proved their case. And I would argue that those same facts apply here. We put in the evaluations, and the jury clearly used those to determine there was just cause. So even if you believe that we should have had the burden of proof, we would have met it based on the evidence and how the evidence came in. The only other thing that I would argue is about the complexity of the case and the meeting of the minds. I do think that the evidence is clear that the jury believed that Dr. Ma had an obligation to fund his research. And when he did not meet that burden, Children's was free to fire him. Unless the court has any other questions.
Thank you.
Your Honors, I think what's overlooked, or certainly not receiving the amount of emphasis it deserves, is the fact that just cause is in this case because this court put it in this case, and it put it.
Because you wanted us to put it in this case.
We absolutely did, and we agreed with the court's decision. But and why we're here arguing is because this court's decision was not given the full value and the full respect to which we were entitled and Dr. Ma was entitled.
So
And that's
counsel,
because-
if there would have been additional language in that instruction that defined what a contract is and cabined the period of time, would that have satisfied you?
Well, I think, counsel talked about the jury discussions, the discussions about the instructions and such. They made a large point in a motion in limine that there should be no discussion about tenure. Well, tenure was the key to this case. That's why the case was reversed. This court found he had tenure. What does tenure mean? Tenure means he has a contractual right to continued employment absent just cause. That means the person who's trying to strip him of tenure has the obligation to establish what just cause is and whether that was met in this case. That was
Let me
never
ask you
done.
about the instruction about just cause that Ms. Bryan was reading from. The language that she indicates came from you all that includes the substance of any documents that form the basis of the employment contract between Dr. Ma and Children's Hospital. So how is that materially different from the italicized language that you're complaining about? Because they look pretty
Well, what-
similar to me.
Yeah, what the court didn't put in, and we asked for that language on top of the instruction request as the discussion went further, and the court told us what he intended to instruct, how he intended to instruct the jury, and I specifically requested, it's on the record, I think pages 1301 or 1303, I believe, you need to put the burden on them, and you need to put in the language at the time the contract was entered into. Well, the contract that was at play was entered into when Dr. Ma was awarded tenure in 1997. And the testimony, and the only testimony that talked about just cause in a tenure situation, was that of Dr. Dagan, who said, in that context, and I'm going to use this, that in effect, the equivalent of just cause in a tenure context is unprofessional behavior. This was not unprofessional behavior. That was the understanding.
So, counsel, do you dispute the neglect of duty definition that your opponent has put forward?
I think neglect of duty without context is not terribly helpful. I don't think there was neglect of duty. He was not stopping his duties. He was not trying to get
So that's
funding.
like not showing up to work at all or something?
Yes,
Okay.
absolutely. I'm not working.
Okay.
He was working. He remained, a valuable member of the faculty. He was terminated not because he was a bad faculty member, not because of unprofessional behavior. He was let go, according to Dr. White, the person who let him go, because he was told from the department, he's not making his numbers, and for financial reasons, we can no longer afford you. Not because you're unprofessional, not because you're incompetent, not because you neglected your duty, but this is a financial matter. It wasn't a contractual matter. There's absolutely no credit given by the jury or in this argument by counsel as to what tenure means. The fact that you're a tenured professor means you have a lifetime obligation to do certain things and to act professionally. He did that. If he wasn't making his numbers, they had alternatives. And that would have been, among other things, take his lab away. You can't do research, Dr. Ma, which is what his lifetime's work is about. That's the impetus to get more money, so you do research. They had those alternatives available to them. No other professor had ever been terminated for this reason. And that speaks volumes as to whether or not this is just cause.
Thank you.
Thank you, Rose.
Thank you both for your arguments this morning. We'll take the matter under submission, issue a timely decision. And we're going to, thank you, Karen, so much. We're going to take a brief recess.
All rise. Court of Appeals, First Appellate District, Oklahoma is now in session. In recess.
That's okay.
Morning again, everybody. So the next case is Finn versus Sizer. And Mr. Turner? How much time would you like to reserve for rebuttal?
5 minutes for rebuttal, please.
Okay.
May it please the court, Adam Turr on behalf of the plaintiff appellants Phil and Marilyn Finn, who will also be referred to as sellers throughout this argument. As the court has seen, this is a simple breach of contract case, but it does set a dangerous precedent for Hamilton County homeowners. My clients were the sellers of a home.
In what way, counsel?
Because what the buyers attempted to do was at the very last minute, after the parties had executed several addenda and they were under contract, the buyers at the very last minute said, oh, we'll still buy the home if you give us a $100,000 discount
Is
for
that-
no reason whatsoever.
Is that really what this case is about? The contract, at least on its face, appeared to be canceled due to rising insurance rates.
The contract, that was pretext, because that notice was sent 2 days after the buyers had already breached the contract. And further, the only reason that the insurance could have conceivably increased, as testified to by the buyers and their own realtor, was because of the water damage, which was...
But I guess I think like my challenge with this case is, like you say this is pretext, you says, you know, they're acting inappropriately, but like you went through a trial and the trial judge obviously disagreed with all that. So
That is true, but the trial judge got most of the facts wrong in the decision, including the very basic facts of the amount, the timing, the process. What's so, the buyers had certain guardrails in place. So when the water damage was discovered after they were already under contract and after their home inspector conducted the inspection, at that time, they could have terminated the contract or they could have renegotiated the purchase price. Instead, a few days later, they execute a post-inspection agreement which waives any further inspections in exchange for some closing credits. So that's step one. Further, they could have had another appraisal done.
Well, counsel, can we pause there for just a second? I want to make sure I understand your argument under the contract. So is it your position that that closing costs, what we'll call the closing costs addendum, that waives the provision that allows termination of the contract for damages, water damage, fire damage, et cetera, casualties?
Yeah, I mean, the contract specifically provides for what happens in the event that there is a casualty damage between contract and closing. And it provides the buyers with two options. Option one, terminate. Option two, proceed to closing. And not only do the buyers in this case elect to proceed to closing, but they negotiated with the sellers to be involved in the repairs that were made, to select the carpet and the paint and the closets.
All right, but I want to focus on the contract. I understand practically that those things happen, but I want to focus on the contract because this is a breach of contract case. So it's your position that that closing cost addendum negated the provision in the original contract that would allow cancellation for casualty?
Yes, because it specifically says in the contract, here are the two options. You can cancel or you can proceed, and they elected to proceed.
Well, does that provision like terminate at some point? Is there a time limitation in it? Is it let me ask this a different way. Are you allowed to proceed or cancel every single day? Or must you elect to proceed or cancel once and for all?
Well, in the event of that particular damage. So there was no further casualty damage that occurred at the property after February 25th, 2021. So February 25th, 2021, you have the casualty damage. Everyone's aware of it. At that time, the buyers can elect to terminate or elect to proceed, and they elected to proceed. There was no further damage.
But their election to proceed was contingent upon remedying the problem, right?
It was not. On March 1st, they waived any future inspection contingencies. And then later on in the case, there was another addenda that was, later on in the transaction, there was another addenda that said, well, we'll continue the closing date one more time in the event that we either have one contractor guarantee the work or we're allowed to have another inspection conducted. So they had the contractual right to have another inspection done.
Did any of those addenda, any of the other ones, address the right to cancel based on changing insurance costs?
No addenda addressed the change in insurance costs.
All right, so the original contract allows cancellation by the buyer due to changing insurance costs.
There are several options for a buyer to terminate a residential real estate contract and increase
A
in
lot
insurance
of them,
costs.
from my experience, trying,
Yes.
yes.
And
Yes.
insurance cost is one of them.
Yes.
And then ultimately, they cancel based on insurance costs. I understand you're going to tell me it's pretext, but on
Well-
paper, that's what happened.
Well, not just that, they breached as of June 25th and then terminated on June 27th. So they terminated a contract that had already been breached.
All right, fair enough. But the explanation they gave for that was insurance costs.
Correct, and the testimony provided was that the only reason the insurance increased was because of the water damage.
Right,
And
and
the
we
con-
have a trial court finding that it was not proven by a preponderance of the evidence that the cause was the buyer.
Right, and we were asking this court to review that and find that the trial court did in fact not rule based on the manifest weight of the evidence presented at trial. The manifest weight of the evidence establishes a timeline where
Was there an earnest money deposit for this
there
contract?
was, and it's still in
And
escrow.
did your client get to retain that?
No, it's still being held in escrow by the realtor.
Okay. I was just curious.
And why is that?
Because there's not yet been a final determination and an order. for
Because
the
I thought
Realty
like that,
Database.
and like, because these contracts are so porous and allowing escape hatches for buyers, I thought that was part of the protection for sellers is there is this earnest money requirement. And if the buyer walks for any reason, or most reasons, I think the seller gets to keep it, at least the contracts I'm familiar with.
When it's in litigation, there needs to be an order
Sure.
determining where that goes. So that is one thing we requested at trial was, as part of our damages, that the escrow money be released to
Right.
the plaintiffs.
And so is that an outstanding claim in this case?
There has been no finding or determination by the trial court as to the escrow money.
Does that affect our jurisdiction?
I don't believe so, because you have a final appealable order here. The problem with the final appealable order is it was one page long and stated 8 facts, 3 of which were demonstrably incorrect. And again, to your point, Your Honor, about escape hatches, there were several, and we agree there are several escape hatches for buyers to utilize to get out of contracts. And in this case, the buyers didn't use any of the appropriate remedies they had. Again, there was an appraisal that was done. If the appraisal came back at a lower value, they could have said, hey, that's one reason we went out. There's an appraisal, the house isn't worth as much as it was when we went under contract. But the opposite happened here. The appraisal came back and said the house is still worth $1.2 million, and the buyers agreed that the house was still worth $1.2 million. They had the contractual right to have a second inspection done, and they didn't elect to do it.
Counsel?
Go ahead, sorry.
You can go ahead.
Concerning that second inspection, wasn't there a walkthrough right before they canceled the contract? And there were wires hanging out, the paint was mismatched, the rug looked horrible, et cetera, et cetera. So, and I understand what you're saying is they used increase in insurance to essentially get out of the contract. But doesn't that have some bearing? If
So
it's
that's a
not ready?
separate issue. So there's one issue with having the opportunity to have a second inspection done. Most home buyers don't get that
But do you
opportunity.
need a second inspection if you can look and say the paint doesn't match, that wire's hanging out of the wall, and that wand was not replaced?
So the contract provides for the buyers to have a walkthrough within 48 hours of closing.
Okay.
This was 4 days. This was 96 hours before closing. And there was testimony presented at trial that the work was in fact completed within the 48 hours of closing.
Okay.
And the buyers did not elect to go back into the home within that 48 hours. They relied on what they saw 96 hours before the closing. Again, another escape hatch they could have utilized, but they didn't.
But the contract contemplates this outcome, and I guess that's what I'm struggling with. So I understand the timing issue, that the closing was supposed to be June 25th, and the cancellation document wasn't executed until 2 days later. I understand that factual landscape. But how do we know that they didn't cancel on June 25th because insurance rates went up? And from my review of the record, that is entirely undisputed. Everyone seemed to accept it as fact at trial that insurance rates were going up. And your position at trial seemed to be that that was because of the water damage, and it was therefore the buyer's own fault that the insurance rates were going up, and therefore they couldn't take advantage of something they caused.
And that's very accurate, Your Honor. The Ohio case law is very clear that a non-performing party cannot cause their own breach.
But like, I mean, I've seen articles just in my news feed about how insurance rates are going through the roof. That's a bad metaphor, for homeowners. And I've seen that in my own home insurance rates, like they're increasing steadily. So like, do we know that it's specific to the water damage, or was this part of the broader increase in rates?
No, the testimony given was that there was a claim, so there was an insurance claim made because of the water damage. And because a claim had been made, it caused the insurance to go up in that 4-month period between contract and closing.
And the trial court, again, made this finding, and I understand you want us to take a critical look at it, and we will. But the trial court still made a finding that the cause of the water damage could not be proven by a preponderance of the evidence to be attributed to the buyers.
Correct, and if this case boils down to that, I think there was enough evidence presented at trial. The only evidence was from the inspector himself, or the only evidence that he did not cause it was from him. But again, it's a res ipsa loquitur case, and if you look at the summary judgment motions as well, which this court, we've asked the court to do, based on the purely legal questions. Again, I don't think there are a lot of facts in dispute here. I don't think there are any facts in dispute. The facts at summary judgment were the same as the facts that were reduced at trial.
I think there are, counsel. I mean, it sounds like, and I don't want to presume what your opponent is going to say, but I can anticipate that the buyers are going to say that they did not cause this damage. And your perspective is that they did. And that seems to me to be a very fundamental factual dispute in this case.
Well, I think that's a legal conclusion, Your Honor. I think the facts are very clear that the agent of the buyers, who's their home inspector, went to the house, turned all the knobs, left. No one else entered the property for 2 days. He came back, saw that there was water spraying from the shower wand, did the same routine of turning the knobs, and got the water to turn off. And we had expert testimony from a plumber that said the only possible way any water could have been emanating from that shower wand is if the knob had been left open for the valve to emit water.
And you're at your time if you want to still reserve 5.
Yes, thank you.
Okay, thank you. Mr. Spillane, good morning.
Thank you. Michael Spillane for the buyers in this case, Dr. McClellan and Jennifer Sizer. May it please the court. Your Honor, there's 2 different areas he's appealed. First, he's appealed the motion for summary judgment that was wrong. This case is riddled with all sorts of factual disputes that would not have made it good for summary judgment. First, the water damage. We had competing affidavits at summary judgment stage of the inspector detailing what he did. He went through the house, he turned the knobs, he marked that the shower wand did not work, returned the knobs to where they were. He proceeded to inspect the house for another hour and a half. All of this is in his affidavit.
Was any claim brought against him?
He was originally in this case, and there was a settlement, a confidential settlement on the matter, so he is no longer a party to this case.
Understood.
He testified, or he, in his affidavit, was in the house for another hour and a half. There was a weird occurrence that occurred that the Wi-Fi went out, so he had to go back into the house shortly after leaving, which was right next to the shower, unplug the Wi-Fi, plug it back in.
Counsel, what's in dispute about this?
Your Honor, whether or not he left the shower handle on. Because all of his evidence says the water was never running while I was in the house, when I went back into the house. That is a question of fact that should be heard by the trier of fact.
Right, so his credibility in, saying I turned the knob back and I put this back in the way that I found it and whatnot, that's a credibility determination that a trier of fact needs to make?
Yes, which would make this not ripe for summary judgment on that fact. As far as the other facts, we also have substantial performance. The Kaufman case was cited. That goes directly to whether or not a contract was substantially performed is also going to be a question of fact that the trier of fact should hear. The duty of good faith and fair dealing. We had competing affidavits of them saying that my clients pulled the rug out at the last second. My client's affidavit went through all the steps they did. They wanted this house. The house got flooded. You are correct. They could have backed out at that point. It was a unique house. They wanted the house. They agreed to several more addendums extending the closing date. And it was only once that they hit the final deadline and it still was not ready to close, and my client was about to give birth to her second child, that their patience ran out and did not close because it could not close by the closing date. Whether or not that's a breach of the duty of good faith and fair dealing is also a
Do
question
you
of fact.
agree that this June 27th, I think it is, the June 27th termination document is a pretext? Do you agree that the insurance costs are not the real reason?
I don't believe that it's a pretext. I believe this is what happens when you have realtors involved who are not attorneys. They sent a letter outlining all of the different issues that they had with the property and why they didn't want to close, including the wires hanging down, the paint not matching, and the insurance cost was on there. The realtor, who has no ability to negotiate contracts, picked up the checkbox form, checked a box, signed it, and sent it over, trying to cancel the contract to get the earnest money back.
All right, so they selected one of what, in your position, could have been several different bases for canceling this
Yes,
contract.
but they provided them with notice of that the property was not in a condition to close for the closing date.
But like paint not matching, I mean, that doesn't seem like a material issue when you're talking about a $1.2 million house.
It is and it isn't. I think the material issue is the closing deadline. That work was still going to have to be done. They had extended this contract several times prior to closing, and I believe a case was cited, the Walters case, where it was a similar circumstance where they waived it because they continued working with them after the closing date expired. Here, every time the closing date came up, the one in May, they extended out to June because they wanted the house done, turnkey to move in, and that way, when the baby was born, that they could focus on the second child and not anything else. And it was the deadline that was the material aspect, that they were still going to have contractors in there working, they were still going to have outside people in there working, and that was going to cause a disruption in their life, and they wanted it done. The facts that
So is this like, I'm almost thinking of like back to torts, like the thin skull case, like is this, do we view this differently because the wife was pregnant? Like I understand, like I moved while my wife was pregnant, it was not pretty, but like I understand why that's a really important factor for her, but is that so subjective that it really shouldn't be considered from a contractual standpoint?
I think it should be considered in the question of good faith and fair dealing of part of their reasoning, and which once again goes to a question of fact for the trier of fact to evaluate of, was this a scheme, as my friend over here has tried to claim, that they were going to damage the house, work with them for 3 months, and then pull the rug out for a $100,000 reduction at the last second? Or was that deadline something they negotiated for that was a significant part of the contract, that they needed the house done, move-in ready for that? And they were willing to extend it several times because they had 9-month runway here,
Right.
and the runway simply ran out.
And I assume there was a time of the essence clause there.
There was, and it's in the standard realtor contract. And going back to your earlier question on the earnest money, the standard realtor contract is as neutral can be in all aspects, to the point that it says parties must agree what happens to the earnest money, otherwise it's held for 2 years or until a court rules on it.
So it's going to be part 2 of this case, right?
It very well could be, Your Honor.
Counsel, with regard to the earnest money claim, do you agree that we have a final appealable order even though that hasn't been resolved?
Yes, I think we had a trial on this. I think the finding was that they were not in breach and that the earnest money should be returned. It's being held in escrow by the realtor, and that once this final judgment, we'll have a ruling by the court of who was right, who was wrong, and they'll have their orders.
What was that issue on the earnest money specifically tried to the trial court judge?
It was not specifically tried. It was mentioned within there of any calculation of damages. The plaintiff did request that it be provided to them and partial satisfaction of what the damages were.
So
that
it
they
was in
received.
their damages calculation?
Yes.
All right, and so I guess conceptually, because they did not prevail, they didn't establish entitlement to that money?
That would be,
position.
I would agree with that position. Another area I want to talk about is the damages calculation. My friend and I both agree on what the proper damages, how they should be calculated. It is it's the price of the contract less fair market value at the time of the breach. He has argued that the only way we can calculate that is whatever the sale price of a sale that occurs shortly thereafter. I think that is a misstatement. I think that the standard is that it's at the time of the breach, and this court can consider several different ways of figuring that out. As argued just here today, part of the argument that my clients were not acting in good faith is that the appraised value at the time of the breach was the sale contract price, that it was still the same number. The Walters case that is cited by the appellees, or the appellants, says that while, yes, a recent sale can certainly be one of the factors, you need more than that. And even in that case where they accepted a recent sale price as the measure of fair market value, they also cited to that an appraised value and expert testimony could also be factors to make that decision. And even in accepting the recent sale price, cited to the credibility of the realtor who testified the efforts they took and why that price was fair. So I think there's a question of even damages here, because I believe that the appraised value was 1.2. The realtor testified that she thought the value at the time of the breach was 1.25. So we have two different factors at that time. As far as the actual sale price of the 1.14, that goes to credibility of the witness, and Mr. Finn testified, we could have got the 1.2. We didn't even negotiate in the same way we did with the original buyers. We wanted this house gone quickly, which puts them at a point of some distress. So I think there's a question of even if there's damages, if there's a breach, because the values are all the same. Further, they also have sought special damages. I think the Sharp case that we cited is directly on point. They want the carrying cost of 2 homes. And the Sharp case takes a look at both the decisions of the First District in Peterman and the First District in Callahan. Callahan finding that you can recover some costs if you have to carry the home after a breach of contract, and Peterman that finds that if you already own the other home, then you can't recover those costs. Sharp took those 2 cases, analyzed them, and found that if you already own your second home, which the appellants here did in South Carolina for about 20 years, then you do not get the carrying costs of having to keep 2 homes in the event of a breach of contract. I think that is clear from the case law.
Well, counsel, none of this really comes into play unless
Unless we get
we
to...
decide that the verdict was against the manifest weight of the evidence, right?
Yes. So let me address that. He cited several points of whether or not it's against the manifest weight of the evidence. He says several facts were incorrect. I disagree with that. The first fact he cites is that the inspector found water damage during the inspection. That is not what the opinion says. It says they hired an inspector, water damage was later found. He even clarifies that in his opinion, as short as it was...
Do you agree that this written decision could have been a little more clear?
Your Honor, every litigator's fear is that anytime you're arguing anything are you going to portray all the facts and get them all into it? I think if any of us could write our own opinions, they would be much more how we want them read.
It's fair.
It is certainly a fear that you have in presenting your case. That's probably the reason you had to prepare so hard. And we've been in this case for hundreds of hours. They were in it for 3 days. But I don't think it was necessarily a mistake, because he addresses that the inspector says he did not cause the damage, which doesn't mean he found it during his inspection. It was found later, and that he says he didn't cause it. So I don't think that's actually a mistake in the opinion. On his second point, the $100,000 difference, I will agree. The trial testimony was clear that the offer reduction was $100,000, not $200,000.
I mean, that just seems like a Scrivener's error.
And I completely agree, and I don't think it materially changes any part
Sure.
of his opinion.
Sure.
And the final fact he argues is that the plaintiff, the appellant here's motivation for not accepting it was basically because they were upset that the buyers caused the damage. There was an email that was the response to the counteroffer where they directly said the delays in this were caused by the damage you did to our beautiful home. I think the trial court, in judging everyone's credibility, it's reasonable for them to have found that was some of the motivation of not wanting to negotiate.
All right, so there was some evidence in the record from your perspective to justify that particular sentence?
Exhibit 18, I think, clearly lays it out that the Finns, through their realtors, copy and pasted an email that said the 4-month delay was caused by the damage your inspector did to our home. So I think there are facts and evidence that support that finding by the trier of fact.
Does that even matter? I mean, let's say we were to agree with the sellers that there wasn't any evidence and that was an improper factual finding. Does that even matter to the ultimate conclusion that the buyer was not the cause of the damage and therefore was no breach of contract?
At the end, I don't think so, Your Honor. I think that what this will come down to is not the negotiations that happen. It would be whether or not the buyers were in a position to terminate the contract because of that the work was not yet complete. And it was the understanding of all the parties, and Mr. Finn testified to it at trial, that the purpose of these extensions were that the sellers were going to complete the repairs in the home. And when they were not completed by the sellers in advance of closing, that the buyers refused to close because the house was not in the condition that was promised to them.
All right, so based on what you just said then the insurance cost is a pretext.
It's one of the factors, Your Honor. I think that the insurance was one of several items in that list they sent to them.
I guess some of the difficulty I'm having with this case, and this is for both of you, is that the written documents do not line up with the facts that were argued at trial, that the evidence that was presented at trial. So it seems that we have a document trial and a people trial that is happening here, and those are not the same. The written documents speak to this insurance issue and that being contemplated within the original contract, but the trial is about the condition of the property. This is a breach of contract case, though, so I'm trying to understand how to look at what it's clear that you all, the parties, wanted the court to know about what took place in the context of the contractual documents. Can you help me with that?
Yeah, not a problem, Your Honor. So the ring contracts had multiple steps to them in getting the work completed. There could be more than one reasons that the buyers could want to terminate the contract, including the insurance claim. Further, the claims that were brought by the appellants here had to deal with whether or not they were acting in good faith on this deal. And that required a lot of factual findings as to what actually happened.
I see.
So this is a breach of contract that has a whodunit to it that is a lot more complicated to get to than parties agreeing that the insurance rates had increased and that the work was not done.
I see. Thank you. That's helpful.
And you're at your time.
Thank you very much, Your Honor.
Thank you. Mr. Tur, you have 5 minutes.
Thank you, Your Honors. A few points. My colleague over here said the house was not move-in ready. That was directly contradicted by the buyer's own realtor. The home was in fact move-in ready, and that goes to the trial court not making a decision based on the manifest weight of the evidence. Even Ms. Sizer, the buyer, said, yes, the home was probably still worth $1.2 million. It was just going to be more of a pain in the butt for us, frankly. And the arbitrary value she assigned to the pain in the butt was $100,000. That's not what real estate contracts are premised on. If there was actual evidence presented at trial to show that the home was worth less or that additional repairs were needed or would cost more.
So in response to the $100,000 deduction demand, was there any counteroffer to that? Like, was there any negotiation at that point?
No, because we argue that 3 days before closing is not the time to make counteroffers. That you're already under contract. There's been an offer, there's been acceptance, there's been multiple addenda executed between the parties, there's been months of communications. 3 days before closing is not the time to renegotiate. And that's where I go back to my original argument, that this sets a bad precedent for any home seller in Hamilton County. If you can be under contract, work with the buyers, make improvements to the property at the buyer's request, and then 3 days before closing, they can say, yo, we still love the house, but we're not going to close unless you give us a six-figure discount.
But isn't that what the parties' contract contemplated? Because there are all these outs, like the mortgage, market could go all over the place, or insurance rates could go crazy, or other things could occur. And buyers, it is contemplated in the contract, can walk away.
Buyers can walk away, but not because they made another offer of a number. It's got to be tied to something. There was never an indication that insurance went up and we're going to associate a $100,000 value to the insurance increase. There was no testimony other than Ms. Sizer's own testimony that it was just an arbitrary number that they came up with attributed to their, quote, headaches. If there was an actual practical number, if there was any evidence presented at trial to associate a number with the requested
And I just want to
reduction.
drill into this because I think my understanding is crystallizing. So the condition of the property, the 100,000 demand, the 4-day beforehand walkthrough, all of that is about the good faith claim.
And the breach of contract claim,
In what way is that a breach of contract?
because they were,
Continue negotiating when the property had not yet closed. How is that a breach of, what provision of the contract did they breach by walking through the property, observing its condition, and making a request to reduce the purchase price?
well, they had agreed to buy it for 1.2, and they agreed to waive further inspections. They had agreed, my clients had agreed to allow an additional inspection. They elected not to do that. The manifest way
What
of the
provision of the contract did they breach by walking through the property and then making the $100,000 price reduction demand?
that in itself was not a breach.
All right, so what is the breach?
Failing to close on June 25th at the agreed upon price of $1.2 million.
Okay, and it sounds to me like both of you agree, and after looking at the record, it appears that no one disputes that the insurance rates went up. The cause of the insurance rate increase is in dispute and was in dispute, but the fact of the increase was not. And the contract contemplates that that is a valid basis for cancellation. So how is there a breach when there was a valid basis to terminate the contract?
Well, again, as I think we've learned even further today, and if you look at the transcript of the trial, that was purely pretext. The entire case was about the condition of the
What was,
property.
what was the amount of the delta on the insurance rates? Is that on the record?
There's no evidence presented to that.
Okay, so we don't know whether it was $100 or $10,000.
And importantly,
Well, counsel, wasn't there testimony from multiple witnesses that insurance rates had tripled? Multiple people said that.
because of the claim that had been made on the property
Yes.
based on the water damage.
Yes.
But importantly, the work was done. I think my friend over here, I said that they have to deal with contractors being in the house. But if you look at the testimony presented at trial, all the repairs were made, and the only things that they complained of were very immaterial, touching up paint, reattaching wires, putting electrical outlet covers on. And then there was testimony that that work was in fact done before the closing date. So there was never an issue that they would be dealing with contractors making additional repairs after they closed. Additionally, they can close on a property without moving into it. I mean, this is a real estate sale. This is not a guarantee that you have to move in by June 25th. They were under contract. They had agreed to buy a home for a certain value. The home, their own admission, the home was still worth what they had agreed to buy it for. And as we've seen, the insurance issue was purely pretext, and it was sent 2 days later.
But it's not wrong, right? I hear you saying it's pretext. Maybe it's the box that they chose to check.
And there was testimony from Ms. Sizer that they only checked the box because their realtor told them that's the box, that's the best way to get out of this.
But there's still evidence in the record, and it was your burden of proof to prove your breach of contract case. There's evidence in the record that rates had gone up. No one disputed that. And the contract contemplates that it can be canceled if rates go up.
And it was not canceled until 2 days after the breach had already occurred and they were out of contract.
But how do we know that the reason for them not showing up at the closing date wasn't the insurance rate increase? That's
Well-
what they said that was the basis.
That's the box that their realtor checked for them, but all the emails showed that that was not the true reason. The true reason was, we just feel like this has been a headache. We're concerned about hypothetical mold or
Maybe
mildew
it's
in the
not,
future.
I understand your perspective that it wasn't the true reason, but it appears that it was a valid reason. And the parties did not dispute that at trial. So what are we to do with that? It's a valid reason. No one said, hey, the insurance rates did not go up. That's false. There's no evidence to that in the record.
Well, then we are asking this court to look at why the insurance went up. And again, there is no dispute as to why the insurance went up. A claim was made because of water damage that we believe the evidence shows was caused by no one else other than the buyer's home inspector. And buyers can't use the damage caused by their own agent, which the contract specifically says if there's damage to the property caused by the buyers or their inspector, it's the responsibility of the buyers, not the sellers. And that's what happened here.
And you are at your time now.
Thank you.
Thank you both for your arguments today. The case will be submitted. We'll get out a timely written decision. Hope you both have a great day.
Awesome.